The first lawyer knocked exactly 3 times. The second checked his watch. The third unfolded a thick folder and whispered something I wasn't supposed to hear. He'll probably sign once he realizes we're serious. I smiled to myself. After 72 years on this earth, 35 years in the courtroom, and nearly 2 decades serving as a judge, I'd heard that sentence more times than I could count. I opened the front door wearing an old robe. Not because I wanted to intimidate anyone. It was simply the comfortable robe I'd been wearing while enjoying my morning coffee. The 3 attorneys froze for a brief moment, apparently mistaking it for something else. Before they could say a word, I greeted them with a smile. "Good morning." The oldest attorney recovered first. "Mr. Benjamin Walker?" "That's me. We represent Cedar Grove Homeowners Association." I assumed as much. He handed me a large envelope. "We're here to demand immediate possession of the property located at 1148 Walker Ridge Road." I glanced toward the oak trees stretching across the valley. "My property?" "Yes." "I'm afraid you're mistaken." The attorney opened his folder. "Our records show the HOA acquired this parcel through a boundary adjustment completed 6 months ago." I looked at the map, then back at him, then at the map again. Finally, I laughed. Not loudly, just enough to make all 3 lawyers exchange confused looks. "What exactly is funny?" I pointed toward the map. "This line. What about it?" "It doesn't exist." Silence. The youngest attorney frowned. "This is the official survey." "No. It's an illustration." The 3 lawyers looked at each other. At that moment, none of them realized they were standing on land my grandfather purchased in 1946. Land that had remained in our family through 4 generations. Land whose original deeds were preserved in a fireproof safe less than 20 feet behind me. And most importantly, land whose legal boundaries I knew better than almost anyone alive, because 22 years earlier, I had personally ruled on a county boundary dispute involving the very same survey markers. 3 weeks later, those same attorneys would voluntarily withdraw every claim. The HOA president would resign, and the county recorder would launch an investigation into how an impossible property description had somehow found its way into official paperwork. But on that quiet Tuesday morning, none of us knew how expensive one bad survey would become. My name is Benjamin Walker. Most people call me Ben. I'm 72 years old, a retired judge, a widower, and the 4th generation to live on Walker Ridge Farm. My grandfather bought these 83 acres after returning home from the war. He built the first farmhouse himself. Every fence post, every barn beam, every stone retaining wall. My father expanded the cattle operation. I planted most of the pecan trees that now line the western pasture. When my wife Eleanor was alive, we'd spend evenings watching the sunset from the front porch. Even after she passed away, I never considered leaving. This wasn't just property, it was family history. About 5 years ago, a luxury subdivision called Cedar Grove Estates began expanding toward the ridge. Beautiful homes, wide sidewalks, a clubhouse, swimming pool, tennis courts. I welcomed the new neighbors. Some even bought fresh vegetables from my garden during the summer. We got along just fine. Until the HOA elected a new president. Her name was Patricia Sloan. Patricia believed the subdivision should continue expanding. The only problem? My farm stood directly between Cedar Grove and the scenic overlook developers desperately wanted. About a year before the lawyers appeared, Patricia knocked on my door. "I'd like to discuss purchasing a portion of your land." "I'm not selling." "You haven't heard the offer." "I don't need to." She smiled politely. "Everyone has a price." I smiled back. "My grandfather used to say the same thing." Her eyes brightened. "Oh?" He always added, "Some things simply aren't for sale." She left disappointed. I assumed that would be the end of it. It wasn't. Over the following months, small problems started appearing. Survey flags appeared near my fence, then disappeared. Contractors occasionally parked construction equipment close to my property line. Workers asked strange questions. Do you know exactly where your eastern boundary begins? I do. You ever had it resurveyed? Several times. Every answer seemed to disappoint them. One afternoon, my neighbor, Carl Henderson, stopped his pickup beside my mailbox. You hear what folks are saying? What now? They think Cedar Grove plans another entrance road. Where? He looked toward my pasture. Through there. I laughed. They'd have to buy the land first. Carl shrugged. I figured you already knew. Apparently, I didn't. 2 months later, I received a letter from a surveying company. According to the document, they intended to perform routine boundary verification. I called the company immediately. I didn't request a survey. Our client did. Who? We're not authorized to say. I am. The survey was canceled before anyone entered my property. That seemed odd. Then came another surprise. The county tax office mailed my annual assessment. One page immediately caught my attention. The acreage listed for my property had changed. Not by much. Just over 3 acres. Enough to notice. Not enough for most people to question. I drove to the county records office the very next morning. The clerk searched the database, then frowned. That's strange. What is? Your digital parcel map doesn't match your recorded deed. She turned the monitor toward me. Sure enough, the online map showed a small section of my eastern field extending into the subdivision, but my recorded deed, the legally controlling document, clearly showed no such adjustment. The clerk apologized. It must be a mapping error. Can you tell me when it changed? She typed for another minute. About 6 months ago. Exactly when the HOA attorneys claimed a boundary adjustment had supposedly occurred? Interesting. I requested copies of every document associated with the change. The clerk handed me a receipt. It may take several days. I'll wait. While she gathered records, I walked downstairs to the recorder's archive. Most people never visited that room. I loved it. Thousands of leather-bound deed books dating back more than a century. Original subdivision plats. Survey maps drawn entirely by hand. History preserved on paper. One of the archivists recognized me immediately. Judge Walker. Retired judge, she smiled. Old habits. I'm looking for the Walker Ridge deeds. She personally retrieved them. Every transfer, every easement, every correction. Nothing had changed. Not 1 inch. When the clerk finally returned upstairs carrying my requested file, she looked confused. Mr. Walker? Yes? I think you should see this. She handed me a recently recorded boundary exhibit. It showed my eastern field reduced by more than 3 acres. Signed, stamped, recorded. But something about it immediately bothered me. Not the map, the legal description. One sentence referenced a survey monument that had been removed nearly 20 years earlier during a highway expansion. I knew because I'd visited that site during an old boundary dispute while still serving on the bench. That monument no longer existed, which meant whoever prepared this description had copied information from an outdated document. I quietly closed the file. The clerk asked, "Is something wrong?" I smiled. I think someone just made a very expensive mistake. 3 days later, the 3 HOA lawyers knocked on my front door. Believing they had enough paperwork to force me off land my family had owned for nearly 80 years. They had no idea that before becoming a judge, I had spent years practicing real estate law, and the very first page in their folder contained a mistake no experienced property attorney should ever have missed. The 3 attorneys stood on my front porch waiting for an answer. Instead of arguing, I simply asked one question. Before we continue, would any of you like to see the original deed? The oldest attorney smiled confidently. We've already reviewed the county records. I don't doubt that. But have you reviewed the original records? He hesitated. Our title company handled that. I see. I stepped back and opened the front door. "Please come in." They exchanged cautious glances before following me into the study. Most people noticed the books first. Floor-to-ceiling shelves filled with decades of legal texts, county history, and property law. Then they noticed the framed photographs. My grandfather breaking ground on the farmhouse, my father repairing the old barn after a tornado, a younger version of me taking the oath when I was appointed to the bench. The youngest attorney stopped in front of one picture. "Were you a judge?" I smiled. "For many years." The room suddenly became much quieter. I opened the fireproof safe beside my desk and carefully removed several leather folders. One contained every recorded deed dating back to 1946. Another held certified surveys completed over the decades. The last contained aerial photographs taken by the county. I spread everything across the table. "This," I said, pointing to the oldest deed, "is where ownership begins." The oldest attorney leaned forward. The youngest quickly started taking notes. Only the middle attorney remained silent. I handed them a certified survey completed 12 years earlier, then another completed 6 years after that. Then the most recent survey, finished only 18 months ago. All three matched perfectly. Every property corner, every monument, every measurement. Nothing had changed. The oldest attorney frowned. "Our survey doesn't match these?" "I know." He looked at me. "How is that possible?" "I was hoping you could tell me." No one spoke for nearly a minute. Finally, the youngest attorney flipped through their own file again. His expression changed. "David," he looked toward the senior attorney. "What?" "The legal description references Monument 14-B. So? It was retired years ago." I smiled. "Exactly." He looked at me. "You knew that?" "I visited the site myself." "When?" "About 22 years ago." The attorneys looked at one another. For the first time since arriving, their confidence disappeared. The senior attorney closed his folder. "Mr. Walker, I think we'd like additional time to review this. Take all the time you need." They thanked me politely and drove away. As they left, my phone rang. It was my attorney, Sarah Mitchell. "I've been reviewing the documents you emailed." "And?" "Ben, I think this goes beyond a simple boundary dispute." "What did you find?" "The survey attached to the HOA paperwork wasn't created this year." "How old?" She paused. "Nearly 18 years. That caught my attention. "You're sure?" I checked the drafting software metadata. It was copied from an archived file. "So someone reused an old survey?" "Not exactly." "What then?" "They appear to have copied an outdated legal description into a new document." That explained everything. The old monument, the incorrect bearings, the impossible property line. Someone hadn't measured anything. They had simply recycled obsolete paperwork. The next morning, Sarah and I met at the county recorder's office. The chief recorder personally joined us. After reviewing the documents, he looked genuinely concerned. "I want to compare these against the archived originals." He disappeared into the secure records room. 20 minutes later, he returned carrying 2 large binders. He opened the first. Original subdivision approval. Perfectly normal. He opened the second. Historical survey revisions. Again, nothing unusual. Then he compared both with the HOA's recently recorded exhibit. His eyebrows slowly rose. "This page doesn't belong." Sarah leaned forward. "What do you mean?" "The legal description inserted here wasn't part of the original filing." He carefully compared signatures, recording numbers, dates, paper stock. Everything matched, except one attachment. Someone had inserted a revised exhibit referencing property lines that had never been officially approved. The recorder looked at us. "I'm opening an internal review." News traveled faster than anyone expected. Within 2 days, county engineers requested copies of every survey related to Cedar Grove Estates. Then the title insurance company launched its own audit. Then the engineering firm that had worked on the subdivision contacted Sarah. Their lead surveyor wanted to meet. His name was Michael Reed. He arrived carrying several rolled-up maps. "I think we owe you an explanation." He spread the plans across the conference table. "Our company designed the subdivision exactly like this." He pointed to the eastern boundary. "It stops here, at my fence." "Then why does the HOA map show otherwise?" Michael sighed. "Because this," he held up the HOA exhibit, "was never produced by our office." Sarah looked up. "You're certain?" He pointed toward the professional seal. "The border resembles ours. The numbering resembles ours, but the formatting isn't." He flipped the page over. "Our surveys always include a digital authentication code. This one doesn't." The room fell silent. Michael looked directly at me. "Judge Walker?" "Retired judge." He smiled. "Old habit," he continued. "Whatever this document is, it didn't come from us." That afternoon, the HOA board held an emergency meeting. Word had already spread that their engineering firm disputed the boundary exhibit. Residents packed the clubhouse. Patricia Sloan stood before the microphone trying to reassure everyone. "Our legal position remains strong." One homeowner immediately stood. "Then why are the county engineers investigating?" Another asked, "Why is the title company reviewing our records?" A third resident raised a different concern. "My bank called. They want to know whether our entrance road is affected." Questions came from every direction. Patricia answered fewer and fewer of them. Meanwhile, Sarah received another email. This one came from the county planning director. He requested that both parties attend a formal mediation session before the court hearing. "That's unusual," I said. Sarah smiled. "Not really. They've probably realized this dispute affects hundreds of homeowners." 3 days later, we arrived at the county administration building. Representatives from the HOA sat on one side of the table. County engineers sat in the middle. Sarah and I sat opposite them. The planning director opened the meeting. "We're here to determine one thing. Who legally owns the disputed property?" For 6 straight hours, maps covered the conference table. Historic aerial photographs, tax records, survey monuments, original deeds, engineering plans. By the end of the afternoon, one fact remained completely undisputed. My family's deed had never changed. Not once. Not in 80 years. The only disagreement concerned how the newer boundary exhibit had appeared in the county records. As everyone packed their files, the planning director quietly said something that made the entire room stop. "The county's forensic document examiner will attend next week's hearing." Sarah looked at me. "That changes everything." I nodded. Because a forensic examiner wouldn't simply compare maps. They would determine exactly when the disputed exhibit had been created, how it had been recorded, and whether it truly belonged with the official filing at all. If it didn't, the HOA's entire claim could disappear in a single afternoon. The county courthouse was already full before 9 o'clock. News crews stood outside. Residents from Cedar Grove Estates filled the gallery. Several local attorneys attended simply because they had heard rumors about an unusual property dispute involving 80-year-old deeds. I had spent decades walking those courthouse halls. This time I entered through the front doors like everyone else, not as a judge, just another citizen asking the court to protect his property rights. Sarah walked beside me carrying 3 binders. "Ready? I've waited 80 years for this." She laughed. "Technically, your family has." "Fair point." Inside the courtroom, the HOA's legal team occupied one table. They looked noticeably different from the confident attorneys who had visited my porch 2 weeks earlier. They weren't smiling anymore. The hearing began promptly. The judge reviewed the filings before addressing both sides. "This hearing concerns ownership of the disputed boundary area and the validity of recently recorded property documents." He looked toward the HOA. "You may proceed." The HOA attorney stood. He presented photographs, maps, subdivision plans, engineering renderings. Most of them looked impressive, but something was missing. Every exhibit showed what the HOA believed the property line should be. Very few addressed what the recorded deeds actually said. When he finished, Sarah stood. She walked to the evidence table. Your Honor, my client's position is based on recorded ownership, historical surveys, and official county records. She introduced the original 1946 deed, then every subsequent transfer, every certified survey, every aerial photograph. Each document confirmed exactly the same boundary. Nothing had changed. The judge nodded thoughtfully. Call your next witness. The county's forensic document examiner approached the stand. She had worked for the recorder's office for nearly 20 years. After being sworn in, Sarah asked, "What were you asked to examine?" "The disputed boundary exhibit recorded approximately 6 months ago." "And what did you find?" The examiner displayed enlarged copies on the courtroom screen. She highlighted page numbers, attachment references, digital filing information. The disputed exhibit was attached to an otherwise legitimate filing. She pointed to a timeline. However, the metadata shows this attachment originated from a different document than the one with which it was recorded. The courtroom became very quiet. Sarah continued. Does that mean the filing automatically becomes invalid? No. It means the attachment requires further review because it does not match the original supporting records. She carefully chose her words. I cannot determine intent, but I can determine that this attachment is inconsistent with the historical filing sequence. The judge took several notes. Next came the county surveyor. He explained how every original monument had been located and verified. Then he projected the GPS measurements collected during the inspection. Every measurement aligned with my family's deed, not the HOA exhibit. The judge turned toward the HOA attorney. Do you dispute the current survey? After a brief consultation with his clients, he answered honestly. No, Your Honor. That answer changed the entire hearing, because if the survey itself wasn't disputed, the only remaining question was ownership. Sarah presented one final piece of evidence, an aerial photograph taken more than 30 years earlier. The image clearly showed my family's fence standing in exactly the same location where it remained today. Long before the subdivision existed, long before the HOA was created, long before anyone claimed the land had somehow changed ownership. The judge studied the photograph carefully. Then he looked at both parties. The historical evidence appears remarkably consistent. Court recessed for lunch. When everyone returned that afternoon, something unexpected happened. The HOA attorney stood before the judge. Your Honor, after reviewing today's testimony, my client wishes to withdraw its claim of ownership over the disputed parcel. The courtroom filled with quiet whispers. The judge raised an eyebrow. Is this withdrawal voluntary? Yes. Does your client understand the legal consequences? Yes, Your Honor. The judge nodded. The withdrawal is accepted. He then addressed both parties. The recorded deeds and current surveys establish ownership of the disputed property. He ordered the county recorder to correct the digital parcel map so it accurately reflected the existing deeds. He also directed the parties to cooperate with county officials to resolve any remaining administrative issues involving the recorded boundary exhibit. The hearing ended peacefully. Outside the courthouse, reporters surrounded both legal teams. I declined interviews. Instead, I walked across the street to the small park where my wife Eleanor and I used to eat lunch during my years on the bench. Sarah eventually found me sitting beneath an old oak tree. It's over. It is. She handed me a copy of the court's signed order. You were right. I smiled. It wasn't about winning. It was about protecting something that mattered. Over the next several months, Cedar Grove Estates elected a new HOA board. The incoming directors met with neighboring property owners, including me. Their first priority wasn't expansion, it was rebuilding trust. They adopted new policies requiring independent title reviews before any future land acquisitions. Boundary surveys would now require verification from licensed professionals and legal review before being presented to the membership. The county recorder also completed its administrative review. The digital property map was corrected to match the recorded deeds, ensuring future buyers, lenders, and surveyors would all rely on consistent records. One autumn afternoon, several Cedar Grove residents stopped by my farm, not to argue, to thank me. One young father smiled. We were worried this would divide the whole community. I shook his hand. It doesn't have to. His daughter pointed toward the pecan orchard. Those trees are really old. They're older than I am, she laughed. That's really old. I suppose it is. A few weeks later, I placed fresh flowers beside Eleanor's favorite bench overlooking the valley. The land stretched across the horizon exactly as it always had. Quiet, peaceful, unchanged. I thought about my grandfather buying the property after the war, my father teaching me how to repair fences, my children learning to fish in the same pond where I had learned decades earlier. Land isn't valuable because of what can be built on it. It's valuable because of the memories rooted in it. The HOA believed old records didn't matter. The court proved they did. They believed time would erase history. Instead, history protected the future. Sometimes justice isn't loud. Sometimes there are no dramatic speeches, no shocking confessions, just careful records, patient people, honest professionals, and the simple truth written on paper long before anyone imagined there would be a dispute. In the end, my family's 80-year legacy didn't survive because I had once been a judge. It survived because every generation before me understood something even more important. Take care of your land, keep your records, respect your neighbors, and let the facts speak for themselves. Thanks for watching. If you enjoyed this story, don't forget to like, share, and subscribe for more original HOA stories, courtroom drama, property rights battles, and justice-served endings every week. Turn on notifications so you never miss our next story. Thank you for watching, and we'll see you in the next video.